Article 219 Justice Canon 2746 Justice is to honor the essence of the living law through due process in rendering judgment demonstrating fair remedy. Canon 2747 The highest respect that may be given to the law of any society is to respect due process of law in recognition of the rights of the law as a living entity, having its own valid personality. Canon 2748 All persons are considered innocent of an alleged controversy until due process is served according to the law and a liability, guilt, has been clearly established. Canon 2749 For justice to be served, a judgment must represent fair remedy. The absence of fair remedy represents an absence of justice. Only when consent is given by both parties at the commencement of a case can fair remedy be properly served. Canon 2750 When due process is disrespected, the law suffers injury as any person may suffer harm from assault. All officers of the law are duty-bound not to undertake such action that brings harm to the living law. Canon 2751 By definition justice can never be present nor rendered within an inferior Roman court, as by its very design only the judge is usually permitted to understand the true definitions and meanings of fictions applied through Roman law and Talmudic law, with all others taught deliberately false definitions and misleading knowledge. Article 220 Freedom Canon 2752 Freedom is a fictional form whereby a person is considered exempt from slavery or imprisonment. Freedom is equivalent to the concept of liberty. Canon 2753 Contrary to being a superior fiction, freedom is an inferior fiction offering limited respite. Under the voluntary servitude system of common law, freedom is considered a right or privilege, therefore assuming the person is already considered property and therefore in slavery. Canon 2754 Freedom and slavery belong to the same system of slavery. The concept of freedom depends upon the existence and practice of slavery, whilst the concept of slavery depends upon the concept of freedom, even if never granted. Canon 2755 In accordance with divine law and natural law, an object cannot own other objects. Only fictions can own other fictions. Therefore the concept of freedom is null and void from the beginning, along with its twin concept of slavery. Article 221 Rights Canon 2756 Rights are inherent legal or equitable social property entitlements granted to members of a juridic society by virtue of their legal status. Canon 2757 Legal rights are significantly different to equitable rights, despite the two merely being listed as rights. Equitable rights may equate simply to benefits and privileges granted to members of a society, juridic person or trust that can be suspended by the trustees at will. Canon 2758 Rights also refers to the tradition and custom in many societies that privileges falsely presented as rights are not generally suspended in the interest of maintaining the fraud of perceived rights. Canon 2759 There are no true legal rights of persons in common law, only privileges. Article 222 Privileges Canon 2760 A privilege, or benefit is an equitable social property entitlement granted to members of a juridic society by favor, birth or condition. Canon 2761 Unlike legal title, a privilege or benefit may be revoked or suspended in a range of circumstance, despite the privilege being deliberately termed a right. Article 223 Slavery Canon 2762 Slavery is a fictional form combining morality, property and commerce, whereby a man, woman or child may be considered legally or morally the property of another, to be sold or disposed as property, and any injury to the slave as commercial not moral. Canon 2763 Slavery is without any valid moral foundation, as it falsely claims a divine right of ownership between objects owning other objects, which defies all known divine law, natural law and positive law. Canon 2764 Slavery is without any valid commercial foundation, as it assumes a property right which can only originate from the owner of all things being divine, yet fails to properly prove the lawful conveyance of these original claimed rights. Canon 2765 Unlike mandatory slavery, which has no moral, or commercial foundation upon which to even mount a claim. Voluntary slavery in the form of common law does identify the right of a man or woman to consent to slavery as surety to a person against which some debt, bond is issued. Canon 2766. Unlike mandatory slavery, the voluntary slave system of common law does not disclose the full nature of its slavery and therefore fails the test of a lawful contract in hiding terms, agreements and obligations, thereby rendering any consent null and void. Canon 2767. Slavery in all its forms, whether mandatory or voluntary, is abolished in accordance with these canons in the Sacred Covenant Pactum de Singularis Caelum. Article 224. Equity. Canon 2768. Equity is the principle of being equal or fair, impartial and even-handed in the adjudication of matters before the law, despite one party holding lower rights. Hence, equity is also used as a term to recognize the lowest form of ownership or equitable title over property. Canon 2769. In regards to property, equity denotes the lowest form of ownership as a tenant and lessee. Canon 2770. Accruing equity does not mean increasing a claim or share of ownership. The acquiring of equity is merely the acquiring of uses under tenancy, not ownership under legal title. Canon 2771. Any claim that increased equity is equivalent to increased claim or share of ownership is a deliberate and misleading fraud. If such a fraud was used as the basis of securing any agreement, then such an agreement is null and void from the beginning. Canon 2772. To claim equity is to claim the lowest rights of ownership, not the highest. Therefore, ownership of equity is the last party to be paid in any liquidation of an estate, only if assets remain. Canon 2773. In the adjudication of contract disputes, the principle of equity is to consider the merits and facts of the dispute without regard to the implicit higher or lower claims of ownership. Hence, by treating both parties as equal, the principle of equity necessarily seeks to invoke a form of justice of the law. Canon 2774. The absence of equity, in particular courts of equity, denotes most clearly the absence of justice. Canon 2775. Decisions of equity do not make the law, but assist in its proper interpretation. Article 225. Culpability. Canon 2776. Culpability is the proven fact of having committed an offense in accordance with the statutes of a juridic person by lawful process. Canon 2777. Culpability is one of only two permitted resolutions of valid verdict, with the other being innocence. Culpability is therefore to be justly liable to penalty. Canon 2778. Culpability is not equivalent to guilt, as guilt implies an acceptance and consent to an immoral act, whereas culpability is a decision made by either a judge or jury in the course of a trial. Canon 2779. A person found lawfully culpable is not permitted to receive the choice of absolution. Instead, it is deemed they have chosen the punishment of penitence as defined by any statutes promulgated consistent with these canons. Article 226. Mens Rea. Canon 2780. Mens Rea is a fundamental principle of law and necessary element for establishing criminal liability, whereby the intent of the accused to knowingly commit a crime must be established as well as evidence of the action of a crime. Canon 2781. The phrase mens rea comes from Latin and means guilty mind. It is derived from the Latin phrase and maxim actus non facit rea omnis mens sit rea, meaning the act does not make a person guilty unless the mind be also guilty. Canon 2782. The determination of mens rea is according to culpability. Article 227. Actus reus. Canon 2783. Actus reus is a fundamental principle of law and necessary element for establishing criminal liability, whereby evidence of the action of a crime must be established with the intent of the accused to knowingly commit a crime. Canon 2784. The phrase actus reus comes from Latin and means guilty act. It is derived from the Latin phrase and maxim actus non facit rea omnis mens sit rea, meaning the act does not make a person guilty unless the mind be also guilty. Canon 2785. In order for actus reus to be committed, a deliberative act must be proven to have occurred involving bodily movement as either commission or remission. Commission is engaging in a bodily movement resulting in an injury prescribed by law, and 2. Omission is failing to engage in a necessary bodily movement for which a duty to perform exists resulting in an injury prescribed by law. Canon 2786. The concept of a deliberative act is a bodily movement that is performed voluntarily. While a voluntary bodily movement may cause an involuntary reaction, involuntary bodily movements are generally considered excluded from the meaning of a deliberative act. Canon 2787. As possession alone does not constitute an act, it therefore can never be argued as actus reus without corrupting the essential principle itself and therefore negating its validity. Canon 2788. While possession itself can never be considered an act without corrupting the law, all possessions by definition are arrived through a series of voluntary or involuntary acts. Therefore, in the case of possession, the source of actus reus is not the possession itself, but the act or acts leading to possession. Article 228. Innocence. Canon 2789. Innocence is the proven fact of not having committed an offense in accordance with the statutes of a juridic person by lawful process. Canon 2790. All accused are considered innocent until proven culpable. Canon 2791. Innocence is one of only two permitted resolutions of valid verdict, with the other being culpability. Innocence is therefore to be free from any liable to penalty. Article 229. Counsel. Canon 2792. The right to counsel is an ancient principle of law, whereby all who are accused may seek the counsel of an advocate of their choosing to present their case before the court. Canon 2793. The word advocate is from ancient Latin advocatio, coming to even earlier Latin words ad, with plus vocare, voice, meaning literally to assist in legal defense with one's voice. Canon 2794. The ancient right to counsel is further reinforced through trust law when an accused as general executor to the trust representing the suit against them may nominate one or more general executors to act on their behalf. When this occurs, counsel is also known as amicus curiae. Canon 2795. Justice requires that the counsel selected by an accused swear a valid oath or execute a valid deed to truthfully serve the interests of the accused ahead of any other interests. A counsel that will not or cannot serve the interests of the accused above other interests is unfit to be counsel. Canon 2796. While a counsel is duty-bound to serve the interests of their client, they are obligated to do so within the confines of the law such that any facts present in defense are true to the best knowledge of the counsel and no act to knowingly or deliberately injure the law is performed during such service. Canon 2797. An advocate that engages as counsel for another while still honoring a higher pledge, oath or association that is in conflict with serving the best interests of their client, whether or not such conflict is divulged, is guilty of an injury of the law and unfit to be counsel. Canon 2798. The word lawyer is from the late 16th century, combining the Latin words la, lares equals, customary law, plus euro, erere equals, to swear, take an oath, to conspire, meaning literally one who has sworn an oath to customary law, of the private guild. Hence the true and original meaning of a lawyer is one who is authorized and licensed by the private guilds of the bar to practice law. Therefore, no lawyer can be counsel without deliberately injuring the law and perverting the course of justice. Canon 2799. The word attorn or attornment is from 16th century, combining the Latin words at equals, to, plus torno, turn, round off, meaning to consent, implicitly or explicitly, to a transfer of a right. Hence the word attorney means literally a person to whom rights have been transferred by consent, implicitly or explicitly. Therefore, no attorney can be counsel without deliberately injuring the law and perverting the course of justice. Canon 2800. The word barrister is from the late 16th century, combining the Latin words baro equals, dunce, incompetent, plus sto, stare, to stand firm, To be in position, meaning literally to stand, represent to dunce, incompetent. Hence the meaning is a student of the law, of the private guild, that has been called to the bar. Therefore, no barrister can be counsel without deliberately injuring the law and perverting the course of justice. Canon 2801. As members of the private bar guild are lawyers, attorneys and/or barristers, no member of a private bar guild can be counsel without deliberately injuring the law and perverting the course of justice. Article 230 Pro se. Canon 2802. Pro se is the principle of law that one may advocate on their own behalf before a court concerning a matter of controversy for which they have been named as a party rather than commissioning another. Canon 2803. The phrase pro se is Latin meaning for one's own behalf. Canon 2804. There are three forms of pro se which one may choose to present themselves, being Roman, person, existence as man or woman or as a tribunal of superior persons. Pro se without any qualification is assumed to mean pro se in personam, which translates as for one's own Roman person or simply under the full jurisdiction of a Roman court, and 2. Pro se in vivus, which translates as for one's own behalf in one's own flesh and blood, which means on who attends or visits court as a living flesh and blood man, claiming such fact and therefore outside the jurisdiction of courts that cannot deal with anything but corporations and persons, and 3. Pro se in triformis, which translates as for one's own behalf in three forms. Persons, which means one who attends court by claiming their live-born record from one heaven and therefore the presence of a superior tribunal of a divine person, true person and superior person contesting title and jurisdiction of any inferior, Roman, court. Canon 2805. Pro se is a choice and a right, not a privilege. No court is permitted to place any conditions upon the acknowledgement of pro se. The court has adequate remedy available within the law should issues of competency, proprietary or due process arise from the behavior of one who chooses pro se. Canon 2806. To deny pro se is to deny the existence of the law. Therefore, no order, ruling, sentence or judgment from a court that denied pro se can be upheld as lawful under any valid system of law. Canon 2807. A court is not obliged to grant any special favor to one who chooses pro se than an ordinary advocate. However, in the interest of justice, such consideration of may be granted. Canon 2808. One who chooses pro se is obliged to act and perform in a manner befitting an advocate of the court, including appropriate professional dress, cleanliness, manners and respect of due process. Article 231. Res accusatio. Canon 2809. Res accusatio is the ancient principle of law that one who has been charged with an offense is always given immediately the facts of the accusations in a form that they can comprehend. Canon 2810. The phrase res accusatio is ancient Latin for the facts of the accusation. Canon 2811. It is both an absurd corruption and injury to the law when one is charged with an offense and the nature and facts of the accusation are not divulged to the alleged offender. Canon 2812. Res accusatio is not the same as indictment, as res accusatio is merely the facts and natures of the charges allegedly against an accused, not the evidence or details of the case to be brought against them at indictment. Canon 2813. Res accusatio is a right of the accused and an obligation of the accuser. When res accusatio is failed to be applied within 3 days of being charged, the injury against the law automatically sets off any account of accusations and the prisoner must be set free with the case dismissed. Article 232. Res judicata. Canon 2814. Res judicata, also known as double jeopardy, also known as preclusion of claim and autrefois acquit, convict, is an ancient principle of law whereby a case in which res judicata was perfected is no longer subject to appeal, nor may the same case be brought again either in the same court, or different court. Canon 2815. The phrase res judicata is ancient Latin and means a matter, already, judged. Canon 2816. Res judicata is considered perfected when 5 factors are found to have been clearly defined in the previous suit, identity of the property, person or thing at suit, and 2. Identity of the cause, charges and facts at suit, and 3. identity of the relevant parties, their actions and intentions at suit, and 4. Whether the judgment was final, and v. Whether the relevant parties were given full and fair opportunity to be heard on the issue. Canon 2817. Once res judicatur is claimed and validated, no judge nor court may hear the alleged pending matter, nor reopen a case against which res judicatur is perfected. Canon 2818. Res judicatur does not preclude the right of appeal, which is considered a continuance of the same case, rather than the reopening of a case. Only when the appeals process is exhausted or waived by all parties does res judicatur come into effect as a principle. Canon 2819. A defendant in a suit may use res judicatur as defense as a plaintiff who prosecuted an action against a defendant and obtained a valid final judgment is not permitted by law to initiate another action versus the same defendant where I. The claim is of such nature as could have been joined in the first action, or 2. The claim is based on the same transaction that was at issue in the first action, or 3. The plaintiff seeks a different remedy, or further remedy, than what was obtained in the first action. Canon 2820. While the concepts of double jeopardy and autifois acquit or autifois convict are sometimes considered separate in rights and statute in terms of res judicatur, it is res judicatur that is the principle of law, not necessarily the question of fairness that precludes a new case on the same matter being brought again. Article 233 is propria. Canon 2821 is propria, also known as jus propria, is the ancient principle of law that justice requires prompt resolution of controversies. Canon 2822. The phrase jus propria is Latin meaning prompt justice. Canon 2823. The absence of promptness is the absence of justice and an injury of law. Canon 2824. All accused have the right to res accusatio, hear the facts of the accusations, before a judge or magistrate within 3 to 7 days of first being detained. Canon 2825. All accused have the right to is propria such that their detention is not greater than 90 days before their appointed final court hearing or trial, unless the accused themselves have requested more time to prepare. Canon 2826. The refusal of res accusatio right combined with the refusal of is propria is such a severe injury to the law, it offsets any account of accusation requiring the man or woman be immediately set free as all charges have been balanced and accounted. Article 234. Meritis formulae. Canon 2827. Meritis formulae. Due process is an ancient principle of law that officials and their agents are duty-bound to follow the same laws they enforce. Canon 2828. The phrase meritus formulae is Latin for due process, procedure. Canon 2829. When an official or agent that is duty-bound by their oath of office to follow the same laws they enforce knowingly and deliberately deviates, ignores or contravenes such laws, their offense is manifestly greater than one who is not duty-bound to enforce the law. Canon 2830. When meritis formulae has failed to be followed 3 times in proper procedure, the law ceases and all offices, authorities and powers dissolved. I. The first failure of meritus formulae, that being a matter of serious law in which the life, liberty or possessions of an accused were unfairly injured and no redress provided, and 2. The second failure of meritus formulae, that being the refusal under appeal of writ of mandamus to accept the first injury, therefore creating a second meritus formulae, and 3. The third and final failure of meritus formulae, that being the government of the people refusing the sanction, the refusal to properly investigate the writ of mandamus constituting a tacit endorsement of the repudiation of the rule of law. Canon 2831. A significant failure of meritus formulae within a court proceeding may be ground for technical dismissal, as the offence of the court against the laws it has sworn to uphold offsets the alleged offence it has sworn to adjudicate. Article 235. Meritis prescriptum. Canon 2832. Meritis prescriptum is an ancient principle of law whereby fair notice is given to an accused to enable them sufficient time to respond, attend and prepare a defense. Canon 2833. The phrase meritus prescriptum is Latin for fair notice, of suit. Canon 2834 Meritus Prescriptum is a fundamental pillar of justice whereby an accused cannot be judged if they were never properly made aware of the accusation. Similarly, Meritus Prescriptum means the ruling over a dispute or enforcement of a claim in which the rights of another are impinged is unlawful if the other was never properly made aware of the claim or dispute. Canon 2835 Meritus Prescriptum requires proof of service in the delivery of a written notice outlining the key facts of the controversy and options available to the party within a prescribed period of time, allowing for an adequate response including I. Physical service witnessed by at least two parties, or 2. Certified mail or courier, or 3. Certified email, or 4. Certified fax or phone message delivery. Canon 2836 Public notice is not equivalent to Meritus Prescriptum. Article 236 Demurrer. Canon 2837 Demurrer is a formal written response to a complaint in suit objecting to the legal sufficiency to proceed. A demurrer asserts, without disputing the facts, that the complaint in question does not adequately state all the necessary and key elements of a valid cause of action and that the demurring party is therefore entitled to immediate judgment or dismissal. Canon 2838 The word demurrer comes from the combination of Latin de, out, down, plus muralis, fighting against. Hence the literal meaning of the word demurrer is to cease fighting. Thus demurrer is a call to the court to cease fighting and denial of consent to proceed until a matter of law is adjudicated. Canon 2839 A demurrer is neither a form of plea or motion, but a formal request of suspension of court proceedings, suspension of hostilities, until the merits of the written demurrer may be examined. Canon 2840 Excluding evidence of public records that contradict the face of the complaint or material facts not subject to challenge. A valid demurrer does not challenge the alleged facts in the complaint, nor contest the ultimate merits of a suit. Canon 2841 There are four forms of demurrer being general, special, to evidence and to interrogatories. A general demurrer is a demurrer which objects to a complaint in its substance in failure to state facts sufficient to constitute a cause of action and or any claimed lack of subject matter jurisdiction. And, 2. A special demurrer is a demurrer which objects to a complaint in its form in which essential errors of fact, scrivener errors, errors contradicting the public record and other special examples may be shown and or claimed lack of personal or territorial jurisdiction. And, 3. A demurrer to evidence is a demurrer which objects to at the conclusion of the evidence presented for a complaint on the ground of insufficient evidence, faulty or incorrectly presented evidence or other technical errors in material presentation. And, 4. A demurrer to interrogatories is a demurrer of answers offered by a witness as evidence for refusing to answer one or more anticipated questions expected to be asked of them. Canon 2842 In matters of criminal law, a general or special demurrer may not be requested and filed until pleadings after the presentation of any indictment. In such matters, the counsel or pro se will respond to the question of plea that a demurrer is requested and that leave from the court is sought to prepare the motion, or the prepared motion is then handed to the clerk to be filed. Canon 2843 In civil matters where a complaint is administratively filed, a general or special demurrer may also be administratively filed in response prior to any hearing. Canon 2844 A presiding judge or magistrate cannot deny the right of demurrer. A judge that denies demurrer outright, or denies leave to prepare a motion automatically provides evidence of some predisposed bias and grounds for an immediate motion of recusal, removal, of the judge or magistrate from the matter. Article 237 Allocution Canon 2845 Allocution is the term used to define an ancient principle of law whereby an accused having been found guilty of an offense possesses the right to speak for one last time on the record as to their defense before any sentence is passed. Canon 2846 The right of an accused to speak to those that have convicted them of a crime before sentence is issued as one of the oldest pillars of law since the beginning of civilization. When denied or wholly absent, No law can be said to exist. Canon 2847. The word allocution is a corruption of the word adlocution, which comes from the Latin adlocutio, meaning concluding speech, inspired, final words, final speech of play, formal address, emperor/general. In ancient Greek law, ancient Roman law, Anglo-Saxon law and early common law, adlocution referred to the third and final right of an accused to speak in their defense. The three forms in Roman law being prolocution, collocution and adlocution. Canon 2848. The most famous use of adlocution for Western law is the adlocution of Socrates, as told by Plato. Thus it has served as one of the ancient pillars of Western thought and justice alongside logic and the very function of law from the beginning. Canon 2849. The most famous non-use of adlocution for Western law after being offered prolocution and collocution in accordance with Roman law is the trial of Jesus by Pontius Pilate as recounted in the New Testament. Canon 2850. An adlocution or allocution is always oral and no time constraint may be imposed upon its delivery and conclusion. Canon 2851. During adlocution may refer to any evidence, whether previously admitted or refused to be entered into the record by the court. Furthermore, an adlocution may include elements of demurrer in challenging the jurisdiction of the court as well as the weight of evidence presented. Canon 2852. In the 19th century, the Roman cult, also known as the Vatican, sought to remove this 2,000-year-old fundamental right of law by claiming its spelling as allocution, reserving its highest use as a solemn private address by the Roman pontiff to the College of Cardinals and its lowest use as a privilege granted by judges of the private bar guild to the accused. Canon 2853. In the 20th century, the private bar guild further corrupted this most ancient foundation of law by claiming allocution is an unsworn statement no longer on the public record if requested by the accused, only if requested by the judge. Canon 2854. Any law, statute, edict, policy or ruling that states adlocution or its variant pronunciation allocution no longer applies and is not part of the public record is an absurdity and abomination against the law, having no force or effect from the beginning. Canon 2855. If an accused had previously stated at prolocution that the court had no jurisdiction and presented facts to support such claim, had then reinforced through demurrer and or collocution the court's lack of jurisdiction, then for the third and final time at adlocution speaks their denial of consent and lack of jurisdiction by the court, then the court cannot lawfully detain or obstruct them from leaving the court at the conclusion of their adlocution. Canon 2856. Any accused that reinforces their non-consent at adlocution by definition cannot be bound, therefore no valid judgment can be rendered, nor bond perfected. Canon 2857. When any accused vocalizes their non-consent and reinforces any facts of non-jurisdiction and demurrer at adlocution, the liability imposed by the court must remain in the hands of the judge or magistrate.